but I do feel enlightened and very much appreciative of having gotten to sit in on the governor's prayer breakfast this morning. So that's why we're running a little bit late. We're anxious, though, to get to a good House bill that came to us from the other side, Uniform Trust Code Amendments. That's House Bill 101. Representative Crago, glad to have you here this morning to walk us through House Bill 101. Let's get started, committee. Okay. Take it away, Representative.
Thank you, Mr. Chairman. Committee, Barry Crago, House District 40. I'm here today to present House Bill 101, Uniform Trust Code Amendments. And I'll just give a little bit of background, and then if it's okay with the committee, I'll have some of the specialists in this area come talk to you about the bill. And if you have questions about the specific provisions of the bill, they can walk us through that as well. House Bill 101 is an attempt to keep our trust code modern. Every couple years, the estate planning lawyers within the state of Wyoming get together. They all work together to come up with ways to keep our code modern and competitive with surrounding states. As other states change their trust code, we're trying to keep up with the times, essentially. And so that's what the bill does. It's a long bill, but it's actually a lot of little word changes here and there. And so with that, I would propose that we just go straight to public testimony from some of those lawyers who actually practice in this area of law, which is actually pretty discreet. There's not a lot of lawyers that do that, and so their expertise is greatly valued by me, and I'm sure it will be by you as well. Thank you.
Really appreciate that, Representative. Any questions from the 30,000-foot view? Okay, let's go to some of your colleagues in the legal world. Representative, would welcome them to the front. And as you know, we like for you to introduce yourself. We've got folks online this morning and out there listening in. So please introduce yourself. Welcome. Glad to see you.
Thank you. Mr. Chairman, my name is Tom Long. I'm a lawyer here in Cheyenne with the firm of Long, Reimer, Weiniger. We have offices elsewhere, including Casper, Evanston, Jackson, Denver, and Park City also, by the way. But our primary office originated in Cheyenne, and I am here to start with a 30,000-foot level comment of my own. We want this bill passed, and by we, I'm speaking on my own behalf as an estate planning attorney. We like this bill because it solves a couple of problems that we have with our trust code, and otherwise it continues to enhance our code as a modern set of statutes that will attract trust business to Wyoming. And I understand that we should have Marty Oblasser and Stephanie Milam, who may testify by video, and there may be others who join, but I will speak primarily about the ones of concern to me. And so my 30,000-foot comment is we've got a couple of problems that are that can scare away a type of trust that otherwise we do a lot of. The type of trust is called a wing. Wyoming, the I stands for incomplete gift. The N and the G stand for non-grantor. So it's a Wyoming incomplete gift non-grantor trust, meaning that the creator of the trust is still considered to own it for gift and estate tax purposes, but is not considered to own it for income tax purposes. And it instead is a separate income taxpayer, and it's something that Wyoming gets a lot of business doing because people who live in places like New York and California would like their money to be taxed at Wyoming state tax rates. So they create a separate tax-paying trust, a non-grantor trust, that is domiciled in Wyoming. And it has to have a Wyoming trustee, and it usually has a Wyoming lawyer. And it needs a nexus with the state of Wyoming, so there are often meetings in Wyoming, and the hospitality industry and the restaurant industry and the spillover of all of that. And the problem we have with our current statute is a kind of a side effect of a solution that was presented a couple of years ago. We had a problem worrying about who has a fiduciary duty with these trusts when there are investment advisors and trust protectors, others who do some jobs for a trust. And under the trust code as it got passed last year, or 2 years ago, sorry, it was clarified that somebody has to be a fiduciary. And in some cases, it ended up being the trust protector or the trust advisor. And that has created a problem for our wing trusts for tax purposes. That interacts poorly with the Internal Revenue Code. A wing trust to work, most people who set up wing trusts want to be able to get some money out of it for themselves. It's not a gift. It's an incomplete gift. That's what the I in wing stands for. So it's not a gift. It's just a separate taxpayer. But to accomplish that and still be able to get their own distributions out of this trust, there has to be a committee of people who approve it, who have to be adverse for federal income tax purposes under the 671 through 679 rules of the Internal Revenue Code. So I'm sorry, over on the House side, I actually got into this deeper into the weeds, and I won't this time, I promise. But in any event, the side effect of our statute 2 years ago was to make these people who serve as adverse, people who have an interest different from the creator of these trusts, made them fiduciaries. And a fiduciary has to put the other person's interest above their own. And so that doesn't work very well for somebody who has to be able to put their own interest above that of the settlor of these trusts. So we are very keen on the change to section 712, which is on page 7 at line 22 is where we start with those fixes. And 718, I'm sorry, is the change. And a comparable change also is being made to line 21 of page 3 in section 105. So those changes, I think, will avoid this problem with wing trusts and will avoid the advocates of Nevada, South Dakota, Alaska, all these states that compete with Wyoming for this kind of trust. It will take away one of their talking points. The other thing that I am keen on is the amendment to section 813. And let's see if I can find that for you quickly. That relates to accountings. That's on page 8, line 9. And the problem with that is that 2 years ago, it basically caused our trust code to retroactively apply to trusts that were created before July 2003. When this bill was first passed 20 years ago, it was prospective. It only applied to new trusts. This has an effect of trusts who moved to Wyoming and are already irrevocable, can't be amended, so they can't alter the effects of section 813. are stuck with a pretty regimented trust accounting regime where, and trust accounting is not the same as tax accounting. Accounting for principal and income for trust purposes is measurably different than how you would do it on a tax return. And what's worse is that our accounting statute says it should be that expenses should be allocated between principal and income, receipts should be allocated between principal and income. Nobody does that other than if you have a marital deduction trust, and you need to know what accounting income is, but our trust code calls for that. And these trusts that would move from out of state to Wyoming, well, I've had one occasion where one told me they don't want to do this if they're stuck with this accounting system. We attract business because we are a no tax, no income tax state, but we also, in my experience, I've had 3 or 4 now come because they like our trust laws. On top of they like our income tax laws. So I am very interested in seeing 813 changed. Now, I also favor all the rest of this bill, but I think Ms. Oblasser and Ms. Milam would speak to all of those for you. But I am open to any questions, Mr. Chairman.
Mr. Long, thank you. Just makes me glad that we have people who know how to do what you do. So really appreciate you being here this morning and
Thank you.
catching us up to speed on some of this. Questions, committee, for Mr. Long? Any questions yet? Okay.
Right.
Mr.
Thank you.
Long, I'll let you slide into the background, and we reserve the right to get back to you if we have any questions. I think, Judy, I'd like to go to those online this morning. There's an indication that we have a couple of folks that might be helpful to us, and would love to hear from them. So,
I'm bringing in Stephanie Milam.
okay. Miss Milam, is it?
Ms. Milam, you need to turn off
Okay.
your, or turn on your.
All right, good morning. If you could please introduce yourself for the record, but welcome. Appreciate you being here.
You're muted.
If you can unmute, we would hear you a little bit better. There we go.
Wonderful. Well, good morning, Mr. Chairman and members of the committee. My name is Marty Oblasser, and I'm a partner with Korthbell and King Law Office over here in Laramie. I appreciate the opportunity to be able to testify in front of the judiciary again, and this time I'll be discussing House Bill 101, well, portions of it in which I support. And while I'm sure this committee finds all things trust and estates riveting, I'll be brief with my comments. As previously discussed by Mr. Long, these statutory amendments are needed to keep Wyoming in the first tier of states for those who are creating trusts. And I would actually also argue that it not only benefits those who are creating trusts, but also gives us an advantage when people are choosing where to domicile their LLCs, because we often see these go hand in hand. Accordingly, the 3 amendments that I'll be discussing today are necessary cleanups to our UTC statutory framework. The first being on page 2, line 11 in front of you is for the definition section found in 4-10-103. And the reason we are asking for this following sentence, a holder of a power of appointment shall not be deemed a fiduciary unless otherwise provided for in the trust instrument, is because this is a generally.
Ms. Oblasser, one moment, please. We do have a quick question from Senator Case.
It's not really a question. I'm having trouble hearing, and sometimes you're dropping away from the microphone, and we're having trouble hearing you. So I'm not sure what that is, but maybe when you look down, I was really having trouble hearing you. That's all I'm trying to say.
Appreciate that, Senator. And I was likewise struggling a little bit, Ms. Oblasser. So if you would lean into the microphone, we want to be sure and hear all of your good testimony this morning.
She could slow down too.
You gotta, we're riding, a little bit slower horses this morning. So
No, absolutely. Thank you for letting me know, and let me know if you're unable to hear me again, and I will move even closer.
That sounds
Uh,
better. Thanks.
No problem. So I was just talking about the first half statutory change, which is found on page 2, line 11 of the amendments in front of you. And we are asking for the addition of this sentence because while this revision is usually generally understood by these states of what a power of appointment holder is or is not, we want to ensure that we have a belt and suspenders mechanism to ensure this doesn't become a source of litigation by pesky attorneys or inadvertently create tax consequences. And so we just want to explicitly state that somebody who holds a power of appointment is not a fiduciary unless the trust says so. The next revision, I'm sorry, Chairman, Mr. Chairman, were you going to ask me a question?
I was not.
Okay, sorry.
But since we have a little pause, any questions on 410-103, the language on page 2? Okay, let's keep going.
Thank you. So next on page 3, you'll see that we are wanting to remove from this statutory provision the word qualified and spendthrift from the qualified trustee definitions. And this is because there are other parts of the UTC that require a qualified trustee, and those trusts wouldn't fit under the definition of a qualified spendthrift trust. And if anybody wants to know what that is, I'll kick it over to Mr. Long, as that's a week-long seminar in itself. But we just want to ensure that the qualified trustee definition also applies to other trusts that people are allowed to create under the UTC.
Okay, let's proceed. And if we need to or want to come back to qualified spendthrift, we will sure do that. But please proceed.
Lastly, I would like to discuss the revision on page 4, line 10 to statute 4-10-302. We are requesting to omit the phrase general testamentary as that language limits the power of appointment. There are actually various types of powers of appointments, just not general testamentary powers of appointment, such as a limited power of appointment. And we just want to ensure that this statutory provision, excuse me, also applies to those other types of power of appointments. So truly, these three changes I discussed is nothing earth-shattering. It is just to help clean up our statutory framework that the legislature has worked so hard on to put us in that top tier states. And while I understand that the committee is probably saddened, that is all I have to present, but I am happy to answer any questions you may have about these 3 changes.
Okay, any questions, committee? Thank you very much. Mr. Blasser, really appreciate you being here. We reserve the right to maybe come back to you if we have a question later. Okay, and so do we have other testimony in the room there this morning? It looks like we do.
Mr. Chairman, I
Yes.
have a.
Please proceed.
Oh, okay. You're looking at me. I'm sorry. I can't tell.
And if you would introduce yourself to us, please. Thank you.
Sure. My name is Stephanie Milam. I'm an attorney here in Laramie at Nicholas and Tangeman. And I'm here to talk about the rest of the changes to the Uniform Trust Code. The first section I'll discuss is on page 4. It's for section 411. There's a minor change to this provision to clear up some repetitive and unnecessary language that appears in a sentence in the statute. The more important change to this section is to make it consistent with other sections to modify or terminate a trust by involving the settlor. That's the person who created the trust. Any questions on that section? If not, I can move on to 412.
Committee, any questions? Okay, Ms. Milam, please continue.
Okay, so 412, which begins on page 5. This change is a modification to make the statutes consistent with Section 411 to provide that a non-charitable trust can be modified or terminated with the consent of the trustee and the qualified beneficiaries of the trust. Without this change, it could require a court to obtain the consent of all the trust beneficiaries, which in some cases could be quite burdensome. Subsection G is also being added to protect a trustee from liability, consenting in good faith to the modification. Any questions on 412?
Okay, it looks like we're good so far. Thank you. Please proceed.
Okay, page 6 is 506. A subsection G is being added to this section to cover certain types of irrevocable trusts, including some called slats. These types of trusts have become popular due to the increase of the federal estate tax exemption and the probable reduction in 2026. This change is providing that these trusts will have continued creditor protection after the death of the settlor or the original beneficiary, depending on the type of trust it is. This is a critique of our trust code compared to other top trust jurisdictions, so it's important that we make this change as well to include these other trusts. Any questions there?
We may come back to that one, Ms. Milam, but thank you.
Okay.
I'm going to let you please proceed.
Okay, and lastly, 704, which is on page 7. Old trusts, there are old trusts out there that don't allow the settlor, the trust creator, if alive, to appoint a replacement trustee because it used to cause estate inclusion and estate tax issues. The IRS, however, issued a revenue ruling clarifying that the settlor's ability to appoint a replacement trustee does not, in fact, cause estate inclusion issues. So this change gives the settlor the ability to appoint a replacement trustee of an irrevocable trust rather than the qualified beneficiaries of the trust who, you know, it's possible at times may be adverse to the person who created the trust. And that is really all I have, Mr. Chairman.
So, Ms. Milam, on subparagraph II there, prior to this, that was disallowed the ability to appoint a replacement. Did I understand that correctly?
Let me get to that page just a second.
That was the paragraph that you just talked about.
Yep. Yeah, that is correct.
Okay, all right. I think we've got it. Committee, any questions for either one of our helpful attorneys from just over the hill this morning? Appreciate both of you being here to testify on the bill. Any questions, committee, at this point? Okay, thank you very much, both of you. Judy, is there anyone else online who would like to testify?
No, there's no one else online.
Okay, I appreciate that. Let's come back to the room. Is there anyone else who would like to testify on House Bill 101? Good morning, Mr. Meyer. Good to see you. Glad you made it back safely from the big extravaganza over there. That's a little bit of a scrum getting out of there.
Yes, yes.
Good morning.
Thank you, Mr. Chairman, members of the committee. Scott Meyer on behalf of the Wyoming Bankers Association. I want to echo the comments that Mr. Long had made regarding the opportunity for Wyoming to stay in the game and maybe even ahead of the game a little bit as we're trying to attract this work, keep this work in Wyoming. With respect to the Wyoming Bankers Association and with our trustees in our various banks and what have you, we think that it's also very important that we take into consideration the assignment of those fiduciary powers and allowing those distribution power holders to do so in a non-fiduciary capacity. With that being said, we would like to suggest a small amendment to the language that's been proposed. that on page 8, line 3, where it says decisions of a trustee, we'd like to insert the word distribution decisions on that particular line.
Okay, that's a proposed amendment. Mr. Meyer, the committee has a copy of that proposed amendment. You were good enough to get that to us yesterday evening, and we appreciate that, and we'll take that up, so.
Other than that, Mr. Chairman, I'd certainly stand for any questions, but I think that all our previous people that testified have pretty well laid out the amendments to this trust code.
Okay, thanks for being here, Mr. Meyer. Any questions? Senator Case?
Mr. Chairman, maybe Mr. Meyer can help me. If we pass all these changes, will it keep the Russian oligarchs happy?
Mr. Chairman, Senator Case, we're doing our very best to steal,
That's what I thought.
to use their money wisely.
Yeah, we know you're out there rooting out evil. We
Exactly.
appreciate that, yeah. Anything else for the Bankers Association, Mr. Meyer? Thanks. I appreciate you being here this morning. Okay, is there anyone else who would like to testify this morning on House Bill 101? Representative, any final thoughts before we close testimony, and then we'll work this bill?
Mr. Chairman, no. I'm happy to answer any questions as long as you don't get too specific about the testimony of the good estate planning lawyers. Nope, I have nothing else. I think they did a great job,
So Senator Cooper.
Thank you, Mr. Chairman. Representative, the proposed amendment, does it add, detract, make any difference really to the bill in your opinion?
It's a good question, Representative.
Thank you, Mr. Chairman. Senator Cooper, I'm fine with the amendment, and I think it was a collaborative effort with, the Banking Association, the Trust Association, and some of the good people that have been here today to testify. I don't think there's any pushback on that. At least I haven't heard any, and so kind of talked to everybody to make sure it would be fine, and I think it's a good addition.
Okay, thank you, Representative. Appreciate it. Okay, we're going to close testimony. What's your pleasure on this bill, committee?
No bill.
Okay, moved by Senator Furphy and by Senator Cooper, but we'll say Senator Furphy, and let's work the bill. Discussion, first of all. Committee, I'll just say this. I've worked in this world a little bit with the help of good attorneys like the former Senate president and others who do this kind of work, and thank goodness we have them around to help us through this maze. This is a really tough area of law, and really appreciate them staying on top of this and keeping us competitive out there. Any questions? Senator Schuler.
Thank you, Mr. Chairman. Not a question, more a comment. I only stay about one day ahead on my bills, and so I was reading this late last night, and I had lots of questions, and I just appreciate Mr. Long because he answered a lot of the questions for me. I didn't have to bother you during testimony, so I appreciate your testimony today.
Doesn't take very long for me, by the way. I don't want to get too far off the bank because the water gets real deep real fast. So I'll just be walking along the beach here. And anything else, committee? Let's go. Any proposed amendments for this bill?
Just a quick comment.
Senator Cooper.
Yeah, I think it's a real clear, straightforward bill. I think it's pretty understandable by everybody.
Yeah.
Yeah.
We could all carry it on the floor.
As long as these folks are willing to come along with us to the floor, I think we should be in good shape.
Yeah, we're not adjourning this meeting until we have somebody to carry it on the floor. I'll tell you that.
Look at the list of sponsors.
Yeah.
Yeah, there you go.
We're covered.
We have
We're covered, right?
we have the captain upstairs awaiting. So
I'll move the motion.
okay, thank you, Senator Case. That's where I was headed next. And does everybody understand the amendment? All in favor of Senator Case's motion to adopt the proposed amendment, please say aye.
Aye.
Any opposed, no. That amendment has passed. And Judy, do you have a copy of that, I understand? Okay, great. That is on the bill, and we're back on the bill. You ready for the question? Okay, Judy, would you take roll on House Bill 101, please?
Senator Case,
Aye.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye. Committee, it seems to me that if, oh, by the way, House Bill 101 does pass the Senate Judiciary Committee, it will go upstairs for consideration. And Representative Crago, thanks for bringing this on behalf of our trust attorneys and our bankers and others. We'll go to battle, and we're gonna ask that Senator Case be a wingman, since he is sharing a desk with the captain upstairs.
Give her stage direction.
So he's right behind her, and we'll be right behind both of them. How's that work, committee? All right,
Lovely.
sounds good. Thank you all for being here this morning. That's the only bill we had up for consideration, so